We're calling to order the Compliance and Amendments Committee of the Sunshine Ordinance Task Force. Could we have the first agenda item, please?
Item number 1, call to order, roll call, and agenda changes. Roll call. Member Wolf?
Here.
Member Wolf here. Member Hinsey?
Here.
Member Hinsey here. Chair LaHood?
Here.
Chair LaHood present. We have a quorum. Regarding agenda changes, item number 4, file number 19118, complaint filed by Paul Ondek against the Police Department for allegedly violating Administrative Code Section 6721B by failing to respond to a public records request in a timely and/or complete manner, was withdrawn by the complainant. He said he received his records, and I notified the Police Department that Mr. Ondek would not be appearing, and therefore they did not have to appear as well. Item number 8, file number 19079, complaint filed by Thomas Piccarello against the Department of Homelessness and Supportive Housing for allegedly violating Administrative Code Section 6725 for failing to respond to an immediate disclosure request in a timely manner. Mr. Piccarello notified me by email that he had received his records, and I notified the Department of Homelessness and Supportive Housing that he had asked that his agenda item be withdrawn.
Okay, thank you. Let's move on to the next item on the agenda, please.
Item number 2, approval of the November 26, 2019 Compliance and Amendments Committee meeting minutes. Are there any changes or adjustments that I should be making? I have a copy of them here.
I don't believe so. Members, do we have any other comments?
I'll go ahead and move the approval of the minutes.
Second.
Okay.
Please call the roll. Or we'll take it by
comment.
acclamation.
Public comment.
Public comment, thank you. Seeing no public comment, we'll take it by acclamation.
No objection.
You're good.
Could we have the next item on the agenda, please?
Hang on. Next item, item number 5, file number 19123, complaint filed by Paul Keenha against the San Francisco Municipal Executive Association for allegedly violating Administrative Code Section 6721.
I'm sorry, do we need to call for general public comment first?
I apologize, yes. Item number 3, general public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Do we have any members of the public who would like to make public comment about anything not on today's agenda? Seeing no members of the public wishing to comment, let's move on to the next item.
I have a point of order. Just noticing on the agenda, like, for instance, under number 4, it says determination of jurisdiction, and then B, hearing on the complaint. We're not having a hearing on these. The hearing is to the task force.
Okay, that's what, I thought they were always set up like this.
No, that was in the way past when the task force was allowing committees to do the full vote.
Discovery, et cetera?
Yeah, we don't do that anymore.
We don't, all right.
No,
So
absolutely not.
it's basically a determination of jurisdiction, public
It's-
records, and forward to the task force?
Right,
Okay,
right. We're just all we're doing is making sure that the file is complete. All the information that we feel is necessary for the task force to make to be well informed.
And that is what we have been doing, but
That's what we've been doing.
yeah.
Just noticing that B part should not be, so I
the
would-
hearing on the complaint should not be included.
yeah.
Okay,
Yeah, the only time, it's not necessarily here, like in, like for number 9, it's not necessarily hearings, but it's more about the referrals for compliance. That's what it really, so we'll
meet the
reword that.
But my understanding also was to meet the 45-day rule, so it's on the record that they've been noticed.
Right, that's the jurisdiction part,
All right,
the 45, that includes the 45-day rule.
okay.
Because we'll state that for every one of those jurisdictional motions. We'll include that it meets the 45-day rule. Okay, thank you.
Thank you for making a note on that. Are we ready for item number 5?
Yes, please.
Item number 5, file number 19123, complaint filed by Paul Kenya against the San Francisco Municipal Executive Association for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner.
Are all parties here? Do we have the complainant and respondent or representative here?
Wait, I know that.
Is the petitioner here? Okay.
Oh, I'm sorry.
Okay,
Yeah,
he-
we call it a petitioner or
Okay.
complainant. Is the respondent here? From San Francisco Municipal Executives? No? Okay.
Okay.
Note that for the record.
Yes, please note for the record, and if we could have the petitioner come up and present your complaint.
Good afternoon. My name is.
Hold on 1 second, she has to start the clock. Please.
Good afternoon. My name is Paul Kniha. I am the employee with City and County of San Francisco, and I am represented by SFMEA union. The union has made some changes into current labor practices without notifying. At least I wasn't notified. I'm not sure if any other members were notified. And when I followed up with them to request clarification on the process, how those changes were made, they failed to respond to me. For the record, I should state that it was submitted early November, and I still have not received the response to my request. I believe that the union, being representing a public agency, and since they are involved in a decision-making process that affects how public funds are spent, I think they should be subject to the same transparency and public record disclosure laws as any other public entity that has access to public funds. That's pretty much my position. I don't know what else I can add.
We're just waiting for the clock to run out or you to step away.
So if you're done, if you step away, then we will just stop the clock.
Sounds good. I can answer any questions if you. Okay.
Call you back.
We'll get to that.
Okay, do we have anyone else who is here to speak on behalf of the petitioner? On behalf of the petitioner? Seeing no one planning to speak on behalf of the petitioner, and the complainant is not here, were we told that the respondent would not be attending?
I sent the agenda to the people who first notified me of who they were at MEA, and
No response.
no response, yeah.
But we,
No bounce
Except
backs either, so
Except this
their
letter.
response, yeah.
they
Right.
sent that letter.
Now,
yeah.
just note that the reason why this is separated out is because it got lost in the paper shuffle. It got stuck to another piece of document in the file, so,
So it was submitted on
It was
time,
submitted
even though
on
we did not
time.
receive it.
yeah.
So at this point, committee members, would you like time to look at this, or would you like to ask questions of the petitioner?
Well, I would just ask, because the respondent isn't here, just ask if there are any persons.
Are there any persons here, members of the public, who would like to speak on behalf of the respondent? Seeing none, we will proceed with our questions and deliberations.
Okay, so I have a question for Mr. Knia.
Mr. Kniha, could you please come back to the microphone? Thank you.
So thank you for attending today. So I'm just wondering, I understand what you're stating, that because this organization has some involvement in, you said in stating in with regards to policy or budgeting or Where are they involved in the process here?
So they are involved. They're involved in the process in the way that they participate in negotiations over the compensation for the employees,
So
for the
collective
managers.
bargaining.
Like bargaining, that's
Are
right.
they your union or
They're the union for
They're the union, and
they
and
are your union? Okay.
that's right. And they have a power to make the decisions that are pretty much final decisions. So when this specific decision question has been made, when I send it was sent to us from basically our HR or accounting people. And when I asked our HR and accounting people how this decision was made, what was the rationale, and how it can be reversed, because I believe it violates my labor rights, the decision that has been made. They said that they were pretty much, their hands are tied. They were not making that decision. This entire decision in this specific case was pretty much made by the unions themselves, and that decision. One of my questions was the fiscal analysis of exactly how much it cost the city and county of San Francisco to carry it out, and by my estimate, we're talking about millions of dollars.
Okay, so before we get into some of those details, we first have to determine, the purpose of our work here today is to determine whether your complaint is within our jurisdiction and whether the parties that are involved are also applicable to the Sunshine Ordinance.
Okay.
So that's our first test, okay? And considering that, reading some of the information that our legal counsel has provided for us, and reading the response letter from the organization, we first have to determine that. That's why I asked those questions, is because if they are contracted by the city, if they receive any money from the city, how were they created? Were they created by any policy body or any elected official, that kind of thing? And from what I'm reading with the information in front of me, unless you have some other information, I don't see that they have any connection with the city, that they specifically are connected only with the employees.
They are connected with employees, but they participate in the decision-making process and they have basically sole authority and almost unlimited powers in terms of making the decision that have a fiscal impact.
But who gives them that authority?
They have this authority. I don't know where they got it from, but basically what happens, they go into a room, they make the decision, and they announce to the city that that's the decision they made, and then the city just carries out this decision.
Okay. So it's a union, so essentially the members of the union elect the board of directors, correct, for the union?
I am not sure what the organizational structure is.
So that it's, because it's, from what I can determine here, it's an independent labor union, an independent organization. It's not a city government entity. It's not a department or an agency of the
It
city.
is not a department, but in the definition it listed, and the definition lists other agency, and
Where is that listed? Where? You have, was that part of the records that you?
as reflected on the SOTF website and the ordinance itself. The about purpose of the ordinance is to ensure that the deliberations of commissions, boards, councils, and other agencies of city and county of
That
San
means
Francisco.
other agencies of the city and county of San Francisco that are considered part of the government. This entity is not part of
So
the local government.
my argument is that by participating in the decisions over how public funds are spent, they are an agent of the negotiation, and they should be falling into the category of other agencies.
Okay, so we have to, the only body of law that we can go by is the Sunshine Ordinance, or the state California Public Records Act, or the Ralph M. Brown Open Meetings Act. So in the Sunshine Ordinance basically consolidates the two state laws into the one ordinance, and our ordinance has special powers to provide some enhancements, but the enhancements were approved by the voters in 1999. So there are two types of bodies in the city that cover the all city departments or agencies, boards and commissions, special types of organizations, and whatnot. But they are determined to be covered under the Sunshine Ordinance under specific circumstances. They are either an actual policy body, and a policy body, and I'm just going to read this verbatim. It's not that long, and it is Section 67.3 of the Administrative Code, which is the Sunshine Ordinance. A policy body shall mean, 1, the Board of Supervisors, 2, any other board or commission enumerated in the charter, 3, any board, commission, committee, or other body created by ordinance or resolution of the Board of Supervisors, 4, any advisory board, commission, committee, or body created by the initiative of a policy body, 5, any standing committee of a policy body irrespective of its composition, 6, a policy body shall not include a committee which consists solely of employees of the City and County of San Francisco, unless such committee was established by the charter or by ordinance or resolution of the Board of Supervisors. And 7, any advisory board, commission, committee, or council created by a federal, state, or local grant, whose members are appointed by city officials, employees, or agents. Okay, so I don't know that it fits into any of those categories.
Could you please repeat number 5? I'm sorry.
Number 5 is any standing committee of a policy body irrespective of its composition.
Could that fall into that category?
No, because the union is not it's not a committee of a policy body. So that would be like the Board of Supervisors having a subcommittee. And so the union is not a subcommittee of any board or commission.
But they do participate in policy decision making.
It doesn't matter. It makes no difference. I mean, a business can be sitting at the table negotiating a contract. They are not necessarily subject to the Sunshine Ordinance until the contract is approved, and that contract would then have to determine whether they are subject to the Sunshine Ordinance, which is usually determined by the city attorney. Now, we can also determine whether that's so also, but I don't believe this body, and according to the information we have, has a contract with the city. This particular organization necessarily has a contract with the city that is subject to the Sunshine Ordinance. I don't see a copy of the city contract in the documents that have been submitted to us. So I have no way of knowing whether it is subject. If the contract is submitted, the contract is subjected to the Sunshine Ordinance or not. And even if the contract is, the question then becomes, who is the contract with? Is the contract with the union, or is the contract with all the employees, every individual employee? So those things would have to be determined at that point. Yeah, it would be kind of a reach just based on logic. I understand the logic, and I would more or less agree with you that because they're involved at such a deep level, but the law is, we have to follow what the law says, and we have to assure that it's being applied properly. So as far as a policy body, it doesn't fall into the rubric that I can find. It may be described in some other body of law.
And you
Like-
might have rights as a
Yes.
a person who is represented by the union. We're not experts in that, and I think you might need to seek other advice about what your rights are in terms of accessing that information.
But I'll put my thoughts in here. I agree that that's not this venue, even though I could see where you're going with your logic, but that's not this venue based on the evidence that we have here.
Right, and it's, under a different body of law, so if it has to
Yeah.
do with labor or employment, there's another commission that oversees that body of law.
And what commission is that?
I'm not sure,
wouldn't-
Civil Service Commission, maybe, they're usually the ones that determine that.
Civil Service Commission?
Yeah,
right?
there may be, the best place to find out probably would be the Human Resources Department here in
Okay.
the city. The only other type of meeting, the other type of body that we have jurisdiction over is called a passive meeting body. And that is described as one advisory committees created by an initiative of a member of a policy body, the mayor or a department head. I don't think that it fits into that one. Any group that meets to discuss or advise the mayor or any department head on fiscal, economic, or policy issues.
That's what they
That,
do?
it might fit into that. I don't know. It's worth for us to deliberate. 3, social, recreational, or ceremonial occasions, sponsored or organized by or for a policy body to which the majority of the body is invited, so it's not that. 4, passive meeting body shall not include a committee that consists solely of employees of the city and county of San Francisco created by an initiative of a member of the policy body, the mayor or department head. It's not that. And number 5, notwithstanding the provisions of paragraph 4 above, a passive meeting body shall include a committee that consists solely of employees of the city and county of San Francisco when such a committee is reviewing, developing, modifying, or creating any city policies or procedures relating to the public health, safety, or welfare relating to services for the homeless. So it's absolutely not that. So the only one that would we could deliberate on is number 2, which is any group that meets to discuss with or advise the mayor or any department head on fiscal, economic, or policy issues. The question is so it's any group. So that could be a neighborhood council or something like that. But the question then, the test of this has to be on fiscal, economic, or policy issues. All that, the purpose of this would mean with regards to open meetings, whether the meeting that they were having with the city would be open for the public to observe. I don't know that, because with passive meeting bodies, the ordinance is pretty clear that it focuses mostly on policy bodies and bodies that are created for mostly in the executive branch. So, for instance, if the union is meeting with the mayor, then the documents that the mayor has is subject to the sunshine, but the documents that the group has is not. because they're not a city body. But if they were having a meeting together, and they were discussing policy issues, not necessarily collective bargaining, which is may not be considered a issue, because that's more about actual contract.
So one extra wrinkle to this is that this is the union that represents the management.
Yeah.
So the decisions that they're making, like in the example that you gave, where it's a union that meets with the mayor, so they're both the union and the quote-unquote mayor. You know what I mean?
They can't be one and the same.
How are they?
Well, this is exactly how they are. In the normal, in most of the cases, when we have a union that negotiates with the management, this is a unique case where union represents the management. So the management and the union representative are essentially the same people.
Yeah, no. Employees are independent of the city government. They're hired to do the work of the city government. It's just like any other employee.
That's right, except for this is the union that specifically represents the management and the decision-making body.
I still don't follow how the union could be considered as part of the city government.
Yeah, so I don't see how your logic of that this is the union that represents the management. I don't see how that should resonate in this particular case.
Yeah, it's a
Yeah.
little bit of a reach I think for us to consider the union to be a part of city government. Because as far as the Sunshine Ordinance is concerned, maybe in some other area of law, it may be described differently. But as far as the Sunshine Ordinance is concerned, this body is not described in a way that would compel it to provide any, to be compliant with this particular law. It may be applicable in some other law, but not in this particular law. We've had many cases with regards to unions before. It's been very clear that the unions, no matter who they represent, are not part of city government. They receive no city funds. They weren't created by city law. And so they've no connection with the city other than they represent an independent group of employees.
I understand that. I would like to stress one more time that this is a very unique type of a union. It's the union that represents the management and the decision makers. So
I realize that, but
Yeah.
be it as it may, it's the relationship of that organization to the city that is what we're here to determine. And whether it's unique or not, it would have to be some compelling evidence. It either would have to be created by somebody to be able to make it a government type of a body. The only other type of third parties that are that have to be compliant with the Sunshine Ordinance is a contractor. So let's say the city contracts with a construction company to do work on the street. Mm-hmm. Well, that contract, all that work that is for that contract is subject to Sunshine because they're being hired and paid to do that work with city funds. Mm-hmm. Employment is in a different realm. And that doesn't, and to be honest with you, it involves personnel issues, and collective bargaining as it has its own set of rules with regards to being done in private. The decisions that are being made by the union with regards to their contract is completely private and independent of city government, or else there would be, it just wouldn't serve the purpose. The collective bargaining process would it cannot be open and transparent. It has to be opaque. Otherwise, people will know, what each other's strategies are, and that's not the purpose of collective bargaining. People have to consult, with their own party. So I'm not compelled, and by our legal counsel, by our history on these matters, by the response from the union itself, I'm not. I'm not finding enough evidence to show that it's connected. Altruistically, I understand your point, but we have to follow the law.
And just to add to that, I've just done another scan looking through the Sunshine Ordinance for negotiations, and there are some reference to contract negotiations and employment negotiations, but nothing that would require the
Right.
kind of disclosure that you're requesting from an outside agency, outside entity.
Right, and so for instance, under 67.8, agenda disclosures, there's a listing of all kinds of things: license and permits, conferences with real property negotiators, conferences with legal counsel, public employee appointment and hiring. That's not collective bargaining. Threat to public services or facilities, public employee performance evaluations. But these are all activities that city government does.
Right, and there is conference with negotiator collective bargaining, but this
Right.
is essentially saying that once a contract has been negotiated, it must be, made public. And at this point, what it is. You want to know how they came to that decision, and that
Right.
does not seem to be available.
Right. Yeah, that would be, if anything, it's the only place that I could see there would be information that could be compliant. But this is the government side that has to provide that information, not the union. And so the government side which is compliant with the government code and with the Sunshine Ordinance, would have to do that. And it would be certain information that was discussed, not necessarily any of the details. It's just the item of business to be discussed, like what's on the agenda. That would be the only thing. And the listing for the organizations with regards to the city negotiator: police officers, firefighters, airports, police, transit workers, nurses, miscellaneous employees, and that's it. It's not management. Management is generally exempt employees, where they're not working by the hour. They're working on salary, which has a whole different set of rules. So, which gets into a little more complexity, which is not really within our jurisdiction either. Yeah, I'm still not finding anything that I can point to. And even going back to the memorandum from our legal counsel, I'm not seeing anything that would relate to allowing
And in
it.
fact, there's mention that the city is not allowed to become involved in the dispute between the complainant and the union. Although this is, I don't know that this is exactly
What
relevant.
section
This
is-
is in our memo at the top of page 83.
Well, there isn't, the subject matter is not a dispute. It's a request for information.
Yeah, either way, we can't compel a private party that is not part of the city government to do that.
I understand that that's the way the law is written, but may be wrong, but I believe that the purpose of the Sunshine Ordinance is to provide complete transparency over how public funds are spent.
It is, but that, then the
And-
request is, but you have to make the request to the right party then.
So
And-
maybe what you're seeking is not to get information from the San Francisco Municipal Executives Association, but from city agencies about the San Francisco Municipal Executives Association.
But there's no anything that I ask from the city agency about this information, their response is, this is the question for MEA. And within MEA, those are the same people who are in the management who made this decision. The very same people that are within MEA. So they're making decisions behind closed doors over how public funds are spent, and they hide behind the shell of private organization that is comprised completely
So-
of the public service.
Okay, so I'll go with you down a little bit this far down the rabbit hole on this. Okay, so let me ask you, do you have any evidence when the SFMEA had a meeting with a public official or a policy body about policy matters?
They don't disclose any of that information. That's what I asked them.
Do you have any evidence that public officials have met with the SFMEA?
Not direct evidence, but only indirect evidence.
Where I'm going with this is, if you have knowledge that they met on January 15th, okay, and that the subject matter was, and you knew that the subject matter was, about a piece of legislation or, that's coming through, the mayor's going to put to the Board of Supervisors or something like that. Do you have any, or do you have any evidence that that meeting took place?
So
that
not
kind of
not a direct evidence. In my specific case, there was an announcement from our accounting or HR, I don't remember exactly, that this specific policy change has been implemented. They just notified us that this has been implemented. And when I asked them why this was implemented, how, and what was the reason for that, they said that all of those questions have to go to MEA. MEA has made this decision, and they have, and the city is just carrying out the decision that MEA has made.
Okay.
So there must have been some kind of discussion that led to this, but I don't know when this
So
meeting took place.
that essentially is between the members of MEA and its leadership. So in the organization's bylaws or their own policies, there are probably some provisions for members to have access or a certain level of transparency to its own membership. But because the union is not a government body, the government can't compel it to release that information. Now, because if SFMEA had a meeting about policy issues with the city, then the city is compelled to reveal that information. So if you got information that the SFMEA had a meeting about policy issues with certain parties that are government employees, elected officials, or what have you, then on the government side, they're compelled to, under the Sunshine Ordinance, to reveal that information.
But all of the people on the government side are within the MEA.
Yeah, but who are they meeting with?
Right, because
They basically met among themselves.
they signed their own contract?
That's exactly the issue that we're having here. That the union as an entity and the management is one body. It's a MEA. So they
It's
met.
not- no.
They met as part of their. So they discuss
be.
it between themselves.
Yeah.
And there is no government body for me to go to
Yep,
to request this
but-
information from.
But sir, are they meeting, within like this building as, during,
I don't know where they're
well,
meeting.
that's the hard part for us. It's like if there was a meeting among employees that was created by, or as part of the work activity of that department to discuss business of the city with regards to that, that's one thing. Okay, and we would have to see some evidence that there was a meeting took place, when it took place, where, what it was for, who organized the meeting, who are the members of that committee or group, that kind of thing. And as I read to you before with regards to the passive meeting body, it would be any group that meets to discuss with or advise the mayor, okay, or any department head. So we would have to know who that department head, or if it was the mayor, when that meeting took place, or how they were advised. That would be the way, but it can't be to this private organization.
So let me ask you this. Would I be able to submit a sunshine request basically against those people from HR, from accounting that has notified us of this change? Can I submit a sunshine request
you
against those people?
You could
That-
submit a request
government.
for their emails with the term, San Francisco Municipal Executives Association, or SFMEA, or contracts or bargaining. And if it was handled on the city email system, that would be turned over to you.
Okay, this is very helpful. I think this may be then another avenue that I can pursue.
And if you keep your search terms narrow, you're likely to receive information more quickly than if you say, I want all of the emails to or from this person over 5 years.
Sure.
That you will not receive a swift response to that.
Yeah, I understand. I personally receive a lot as a city employee. I receive a lot of sunshine requests. So I certainly understand that the more narrow and more specific request is, the easier it is to comply with it.
Yeah, and just know it's very rare, again, very rare for third parties that are not created by the government for the Sunshine Ordinance to be applicable to them.
See, I'm just an employee. I don't know that much, and I don't know enough about how they were created, what their legal status is, what their rights, what their responsibilities are. To me, I look at it, A, as an employee, B, as a member of the union, but C, is as a taxpayer. So I believe that my taxes, and if they're making decisions about how my tax funds are spent, they should be accountable to me as a taxpayer, not necessarily as a union member or as an employee.
I agree, but I belong to a neighborhood organization. Okay, it's an independent nonprofit, gets no city funding at all. There may be people in the organization that are employees of the city, or what have you. We have a meeting with a supervisor about a policy. Okay. No one can compel our organization to produce any documents.
Sure.
Okay, but the supervisor has to.
Right. I understand. I understand that.
And that's the way it's somewhat kind of black and white for us with regards to cases like this. Now, that's the question, is the people who were meeting together, were they meeting together as city government employees doing that work that's in their job description? So who are they, essentially, who are they representing? Are they representing the city, or are they representing the union at that point?
Well, that's exactly my point, is that because of the unique structure of this specific union, essentially they're doing both, because they're the management and the union. With any other type of union, you have, if it's a private sector, you have a corporation interest and the labor and the workers that work. In the public sector, you have the employees and the management that negotiate and bargain and apply checks and balances. In this specific case, we have the management and the union, because this is the union that represents the management. So they bargain against each other. There's no checks or balances.
So I'm not following you. You're saying that the people who are doing the collective bargaining are the same people who are in the union?
That's right.
I'd need more evidence to see that.
Well,
I don't think that's
I don't
possible.
think that's,
So
In our-
this is the MEA. This is the union that represents the management.
Yeah, but I can't, but from what you're saying is that the members of the union are the ones that are actually making the decisions about with regards to the collective bargaining
And that is
on behalf of the city.
That is exactly what I'm
I
trying to
need
find out.
s-
That's
well,
exactly what I'm trying to find out. And the only way for me
then
to
you need
find
to-
out if I
you-
submit this
you-
request.
But again, this particular union is not, we don't have jurisdiction over the union. We have jurisdiction over the employees and the work that they do, but we don't have jurisdiction over the union and its members.
The
That's just the way
members,
it is.
all the members of this union are the executive.
I know, but once they step
managers.
outside of the building and they're off the clock and they are part of, members of that union, going to that union meeting, they are not part, Sunshine doesn't apply to them at that point. It only applies to them in the course of the work that they're doing for the city. So if they are representing the city on the collective bargaining side as the city, okay, that's one thing. That's one thing. But it's not the union that's doing that. The union is representing the employees on the other side of the table.
And with any normal union, yeah, that's how it's supposed to be.
Yeah, I know, but that's
how
what I'm
it's-
saying is I don't see any evidence that's in our packet that is describing.
But this is not the evidence that I can provide. I'm not, I
Well,
don't
but
know
they-
anything about the union. Any information that I try to receive from them, they ignore. They do not give me any information of how they make these decisions, who participates at those
Are
negotiations.
you a member of the union?
I am.
So you have to read your bylaws and the policies. to
They don't
determine
provide
what
any of
they-
that information. They
Well,
don't tell,
that-
they
that's
don't.
not, but that's not the business that we have jurisdiction over. That's
I
what I'm saying is you're gonna have to go to the union, find out what their rules are with regards to transparency of information. And that may involve other state law, federal laws but not
That
the
we're not
Sunshine
aware of.
Ordinance.
Yeah.
So if it has to do with folks that work in this building and the meetings that people in this building are having with this organization, that's a completely different question. That we have jurisdiction over. But your complaint is specifically to this third-party organization that is not a government agency. It is not created by the government. There are some provisions with regards to information from those meetings together that may have to be revealed, but that is the responsibility of the government side, not this organization. Organization's not compelled under Sunshine. The government is.
I understand your position.
So I'm going to recommend that we move, unless you have additional
I
questions.
don't.
If
I'm
we-
done.
We can move to rebuttals.
Yeah.
Oh,
Yeah,
we don't have rebuttals. Never, thank you.
Not the process.
we
Sorry,
don't.
I got confused. Okay, in this case, do we have any other different questions, or do we need any additional information to make our decision?
No.
Then does the committee have a motion?
I move that we find no jurisdiction.
I'll second.
Okay, please call roll.
You need to call public comment.
Oh, public comment. Is there any public comment from anyone not involved in this case regarding this matter? Seeing no public comment, let's call roll.
Member Wolf?
Aye.
Member Wolf, aye. Member Hensy?
Aye.
Member Hensy, aye. Chair LaHood?
Aye.
Chair LaHood, aye.
The motion
The
passes.
motion passes.
Thank you for your time.
Thank you. Let's call the next item, please.
Item number 6, file number 1, file number 19109, complaint filed by Stephen Malloy against the Department of Public Health for allegedly violating Administrative Code Section 6724, 25, 26, 27 by failing to respond to a public records request in a timely and/or complete manner.
Do we have the petitioner here?
I made sure to separately remind the petitioner that he had to be here, and he said he would be.
Okay,
So not only did he receive the agenda, I did a follow-up email.
okay. And I'm not seeing anyone
He's
in the
not
audience
here.
respond. The petitioner is not here.
Petitioner's not
Out of
here.
curiosity, is the respondent here?
The Department of
I-
Health?
I will
Yeah.
say that Mr. Malloy had said that he was, there he is.
Oh,
Okay.
Malloy?
Mr. Malloy, we're just
Sure.
about to hear your
Your
case.
timing was perfect.
Okay, so we have the petitioner here. Do we have the respondent or a representative here?
The Department of Public Health.
It seems that we don't have anyone here from the Department of Public Health, but they were notified that this was on the agenda today. And
Yeah,
they didn't say
everyone-
anything.
Yeah, Veronica Vane is the custodian of record for the Department of Public Health. She's my contact. I did send her a copy of the agenda, and I also sent her a copy of the notice of appearance, so.
Okay, well, I think we're going to proceed at this moment and give Mr. Malloy a chance to present his case as soon as he's,
I would just note for our administrator, for parties that do not attend, that needs to be included in the communications to the Sunshine Ordinance Task Force for the hearing, because that would be against our procedure. And there may be a violation with regards to that.
The minutes will more than likely be ready for the February 5th hearing. So when I schedule this particular matter to be heard before task force, I will make a note. Shall I put it on the agenda?
I think it needs to be specifically notated in the recommendation when we send it up to the,
Okay.
in our
Okay,
recommendation.
In our motion?
Yeah, in our motion, we'll notate it,
Okay.
okay?
okay, if,
Do
give
you
us,
want us to access the monitor, Mr. Malloy, or?
do
or
you
are
need to
just
use
putting
the
your papers?
overhead, or are you just putting papers down?
Oh, yeah, sure, I can use that. I was at another meeting, you just like, I don't know how to use it, but I see people just put the paper down, right?
Oh, the light went on.
I think it's automatic.
Let's see if we can see it.
But more than anything, I'm here to really answer questions, I think, and help clear up any issues or anything I can do to help explain the
Okay,
situation.
so hang on one second, we want to make sure the clock is ready.
Yeah, hang on a second.
Because only 3 minutes, right?
5 minutes.
Five.
Let me know when you're ready to start.
Okay. I'm good.
Ready?
Okay, thank you, members. I basically am here, this one is Department of Public Health or?
Public health, yes.
Okay. So for DPH, I think you have a number of supporting documents. And the long story short is I filed back in May of last year. And in an egregious delay, the city did not respond to me. Veronica Vane did not respond to me till almost, I think, November. And when she did, I specifically said, can you release any of the records, essentially on a rolling basis? And she said, as you'll see in the emails, yes, I can do that. I'll send you a first catch now. And so I got that. There were 9 emails with about 13 city officials on them. And the reason the emails are critical is I'm involved in a collective bargaining under PERB where they have cited the city for retaliation against me for reported disclosures. I was the independent contractor working for UCSF at the city's sobering center, which handles the homeless clients, particularly the high utilizers of multiple systems. I was case managing and dealing with those clients, and long story short, the city was allowing patients to call workers who were gay faggots, workers who were black, ugly-ass niggers, and workers who were women, bitches, sluts, and whores. And when I reported that, they took exception with it, and they wrongfully terminated me. Ms. Vane, after the egregious delay, allowed the city attorney, Jonathan Yank is the one who's representing the city in terms of the case, to scrub the records, improperly redact records, and hold records in secret. When she released the 9 emails, they indicted the city officials for official misconduct because I'm a protected veteran, and as a consequence, you cannot retaliate against me unless you follow specific federal jurisdictions, of which they did none of that. And they violated the city independent contractor provisions under equal employment and sexual harassment. So Veronica has refused to release that remaining catch. She has refused to release any records. And the city attorney, without citing attorney-client privilege, has just gone gag order mute. So I clearly would like the public records to be released, all of them. And part of the problem is I get badgered in this process. Not only do you see that it takes months for them to respond, when they do respond, they don't provide all the records. And they put the ownership on me to tell them who in the city conducted the misconduct. I don't know that. The emails and the records indicate that, all the way up to Greg Wagner and Mickey Callahan. That's the fact. So I'm just simply asking, release all of the public records so that we can inspect them. And they're refusing. That's the story. Any questions that I can answer for you?
So there's still time on the clock, but if you,
You're saying DPH is refusing or HR?
Both, but DPH specifically,
Specifically.
because Veronica got an immediate disclosure request from me back at the end of May of 2019, and she refused to respond until November. And then when she did, she released the 9, which was a mistake. Jonathan Yank put her in pause, and then she's refused to release anything since then. And Jonathan is not redacting anything or providing anything per the Sunshine Ordinance, which he must. So they're just got a gag order going on where they're not allowing her to communicate, and they've got a refusal to hold the records and withhold them in secret. And that's it. That's the DPH scenario. And the Ethics Commission, Mr. Pierce and Thomas McLean, have a preliminary investigation where they're making determinations at this point if they're going to proceed for official misconduct, and that can be verified with both of those officers as well.
okay, we've just got 20 more seconds on the clock, but if you're done, if you step
I'm
back. Okay. Okay, are there any members of the public here to speak on behalf of the petitioner? Seeing none, we call for the respondent. Is there anyone here speaking for the respondent? Seeing no one, are there any members of the public speaking on behalf of the respondent? Seeing none, members of the task force, what questions do you have for our petitioner?
I have, Mr. Malloy. So first question I have is, you stated that that there was no attorney-client privilege in writing. Can you explain why that would be necessary?
Improper government activity, of course, is when you use your influence in the office to affect non-compliance with regulation. So I filed a complaint with Mickey Callahan on December 17th of 2018. My case began on October 10th of 2018. Ms. Callahan never responded. And under the city's sexual harassment policy, you cannot ignore a complainant. You have to respond to the complainant. And under the city EEO policy, subcontractors and contractors, as well as sexual harassment, are covered. So the city made a conscious choice to retaliate by virtue of silence.
But what is, my question is about attorney-client privilege. You stated that there was no attorney-client privilege with the city attorney in writing.
Correct.
Why do you feel that that's necessary? I mean,
I don't feel that it's necessary. I feel that all the records should just simply be released. But what's clear is they stopped Ms. Vane from releasing any more records when I got the 9 emails, because now those are findings that
Yeah,
courts.
I understand, but I'm asking a very specific, narrow question. You stated that there was no attorney-client privilege done in writing. So why is that? Because it's unusual for us, that if any employee or any department were to engage the city attorney for any particular reason, generally attorney-client privilege is automatically imposed.
I probably am just saying that based upon my limited experience. So the DA's office cited attorney-client privilege in terms of them not releasing records.
Right.
I believe Department of Human Resources cited attorney-client privilege as part of them not releasing records.
For instance, would the Department of Human Resources be the client or the attorney?
They were my, I was their contractor. So that was my relationship.
So let's just for the sake of just being clear, attorney-client privilege is applicable to the attorney. The attorney can't reveal what the client can reveal whatever they want.
Right.
That's up to them. But the attorney can't reveal the information or the details regarding who they're representing in that kind of way. So if you were to ask the city attorney for the information, city attorney refused under attorney-client privilege, that would be applicable.
Right.
Okay? It's the other way around. If the Department of Health said, we're not releasing it doing attorney-client privilege, that would be incorrect. Okay? It just means that they could say all the information is with our attorney.
Right.
And because of attorney-client privilege, our attorney's not going to
Right.
reveal it to you.
I
So-
received no such communication from Department of Public Health.
Okay, so let me ask you, what kind of records are these? Are these personnel records, investigative records?
At Department of Public Health, because I worked as the independent contractor for DPH, there are a series of emails between the chief of integrity for the city, who is listed on there, the chief of diversity, the chief of EEO, the chief of Department of Public Health. They were all involved because I was a state employee in deciding, do we or don't we participate in the termination of Mr. Malloy? They chose to do that. That is illegal. As a protected veteran, you may not cross into federal jurisdiction and bring charges against me in that manner. Also, as a state employee, you cannot, per my work contract, which is the 7/1/18 Regents City DPH contract, the city cannot in any shape, form, or fashion participate in administrating in my work or personnel affairs. But the city sent DPH EEO manager Hallie Albert on October 3rd to charge me with gender discrimination for engaging in a conversation at work with my coworkers where I pointed out that management was straight, I'm gay, faggot's not okay. Management is primarily white, I'm black, ugly ass nigger is not okay.
Right.
At that time, DPH sent EEO manager Albert to interrogate me unlawfully. She breached the contract, and they were communicating about that.
I get that, but that's not applicable for the Sunshine Ordinance. What we're here to do is, if you requested documents or information
Right.
that you not received, were not, complete, in that kind of way, or they were over redacted or anything like that.
And
That's what we're here to talk
Right.
about.
So Ms. Vane did not release all of the records. She stated on the record, I have more records for you. But when it became apparent that the emails she released, which are my public records, indicted the city officials for breaching my contract, all communication with me ceased no further records were provided, even though they had gone, Veronica was very clear, I have more records for you. But she stopped and refused to communicate.
So she didn't even say, I can't give these to you for some other reason. She did
No,
not say why.
I've just had silence.
So you've had silence. So do you think there are more records?
Yes, absolutely. She herself said in your email thread, you will see where she says, Mr. Malloy, I will release this initial cash to you, and then I will send you the remaining. And then when I got the emails, I immediately provided them to the investigative teams, and then that's when the City Ethics Commission kicked in, that's when the City Human Rights Commission kicked in, and that's when they came under investigation. What happened was nothing was then continued to be provided to me, as it should under the Sunshine Ordinance, because she already released the initial catch, and there's many more.
Okay.
But because they're important, powerful people, and they were emailing about me and discussing me, when I got the records and they went to the investigative teams, of course you can't do that. That's misconduct. So that's a great question. Bottom line, just silence.
Okay.
No one
That-
said
that-
anything.
That's really the crux of the
Yeah.
matter here, right?
Yeah.
Okay. It's,
Yeah, do we have any other questions?
so I'll move to find jurisdiction and that we complete the 45-day rule and that the records are public because we have no reason to believe otherwise because the respondent's not here to cite any law that these records are protected or exempt or what have you. I'm not.
Are you also going to note that the fact that they were not here should be
Yes.
carried to the task
Right,
force?
that the respondent was not present as required by our rules, and that a representative was not present either. I don't see any documents that were in our records that are redacted, so I'm not going to bring that up.
There was something, but it was, if I can find it, it was unclear whether it was an attachment or something. There was something that was blacked out in almost in its entirety.
That's under Department of Human Resources.
Okay.
That's between Mickey Callahan and Greg Wagner on me, and Henry Vong redacted that section. And he did so improperly.
Because it was like the whole
Right,
document.
and he
Yeah.
didn't
Yeah.
do the redaction as he's supposed to under the ordinance.
Yeah, but that's not a.
Yeah, separate issue, but
No.
Yeah, it's not a D.
that's not a
regarding this.
DPH. The DPH you can see.
The other thing I would add to this is, and also to make a recommendation that the task force look to 6721 to compel the respondent to disclose the public documents. 6721. It's I don't remember which. It's just to review 6721 to compel the department to disclose the public records.
So that's the motion. Cheryl, do you have, I know there was a lot.
To find jurisdiction, note that the representative from DPH was not present, and make a recommendation under 6721 for the department not being compelled to turn over the records.
And
Right.
there was one more that was in there was that the records are public and that we have had this hearing within the 45-day rule.
Do we have a second?
Oh, second.
Okay. Is there any public comment on the motion? Seeing no public comment. As soon as Cheryl's done typing, let's call roll.
Member Wolf?
Aye.
Member Wolf, aye. Member Hensy?
Aye.
Member Hensy, aye. Member LaHood? Chair LaHood?
Aye.
Chair LaHood, aye. The motion passes.
Thank you very much. Let's call the next item, please.
Item number 7, file number 19110, complaint filed by Stephen Malloy against the, excuse me, against the fire department for allegedly violating Administrative Code Section 6724, 25, 26, and 27 by failing to respond to a public records request in a timely and/or complete manner.
So I know the petitioner is here. Do we have someone from the fire department here? We do. Great. So, Mr. Malloy, if you could come back up, and we'll give you 5 minutes to present your complaint.
Thank you. Thank you for the other one as well. You all do have the email that I sent, correct? Cheryl, with this thing, do you just put it down and it shows?
It should, yeah. You put it down and we press the button. And it,
Right, you both can't leave.
Actually, can you come back? I'm coming back. If you could pause the clock for 1 second. Thank you.
I'm just going to
She
reset
had to
it
go.
since we got interrupted.
Yeah, thank you. Sorry about that. Please proceed. Actually, pause the clock again. I guess we need the overhead.
It says video.
It says video, yeah, I know. Got this the other day. I don't know why it says video.
Does that say overhead?
No, it just says video. I don't know why. It's the,
We don't need it, it's okay.
are you sure?
Yeah.
Did you want to read it into the record?
Is this information that is not already in the record?
No, I think it's in the record.
Okay.
Oh, I think this thing is sitting on top, maybe that's why.
No, that's, hold
It's
on.
okay, it's okay. You already have the
Okay.
email, so it's fine.
There's a switch. No switch, okay.
Apologize, Mr. Malloy.
No, it's totally fine, you have the email.
Okay, should we restart the clock one last time?
Well, I stopped the clock.
Oh, you stopped it. Okay, great. Thank you. Okay, we're ready.
Go ahead, Mr. Malloy.
All right, thank you. In terms of the fire department, similar timeline, May 24th, 2019, sent in an immediate disclosure request, did not hear back, egregious delay until September 13th. October 8th, I reached out again, I did not hear back. October 11th, fire did respond to me explaining that there was a internal issue that they had. October 19th, but on October 11th, they said they did not have any records. On October 19th, I started the complaint process with Ms. Ledger. On November 6th, fire said they had 1 record. Then on November 6th, again, fire did not tell me existence, form, or nature of records. As part of my complaint on January 18th that I sent, which you all, I think, have the Word and PDF document of, Fire then responded that they used Captain Simon Payne, Captain Brandon Chatham, and Captain April Bassett, who I worked with intensively over the 6 months that I was on the job, and they then released, I think, about 800 emails or something of that nature. So for me, as the complainant, it demonstrates again understanding the background of what's going on, that I have an egregious delay. I have what for me is a badgering where I always have to provide the additional information, which should not be necessary. I rode in those fire trucks for 6 months. I had amazing, highly sensitive, confidential information of every patient in the city of San Francisco that is on their phone, that is on that laptop, that is an encrypted system, that is a superb system. And I worked with them in relationship to that system. So you cannot tell me that you can't put my name into that database and do a search collectively that demonstrates not that I communicated just with Captains Chatham, Payne, and Bassett, but that fire leadership may be coordinating with DPH or DHR or other entities and creating more written public records. And so this tit for tat and this constant fight of where I have to keep escalating the case to keep getting more emails always leaves out the most critical piece, which is Ms. Ledger correspondent says, you must be able to say that there are no records at all in the entire system, not just in relationship to what the complainant has put forward. And so it's my belief, I don't know because I don't have access to the system, that fire leadership communicated with other city officials, just like we see in all the other departments, and those records too are being held in secret and are not being provided to me. Fire has communicated, but the answer to that question, I don't know. And so as a task force, what I'm asking is to compel them to truly do a search without me having to provide a name in that encrypted database, which I know is excellent, and determine who else may have created written records about Stephen Malloy, and to release those other public written records that may exist within the fire database. That's my request today. And that's it.
If you're done, you can step away.
Sure.
Thank you. Is there anyone else here who would like to speak on behalf of the petitioner? Seeing no one else, we'd like to invite the respondent to come up, and you will have 5 minutes to present.
Good evening.
Give us 1 second. We're going to reset the clock. Please tell us who you are and begin.
My name is John Tucker. I'm with the San Francisco Fire Department.
You're gonna have to speak up.
I'm sorry. My name is John Tucker. I'm with this fire department.
Great.
I just want to give a little background here. We did receive the immediate disclosure request on May 24th, 2019 via Next Request for the Public Records Act. And it was for everything of public records concerning Stephen Malloy. We received that we got to on September 13th. The compliance officer and myself asked Mr. Malloy for clarification regarding the scope of his request, as it seemed a little broad for everything of public record concerning him. We asked for, he replied with any correspondence emails from April 1st, 2018 to the present day, so it narrowed it down to that. Mr. Malloy didn't provide any sort of reasonable specific names at the time for our IT person to go through and look to get the records. On September 19th, we responded that the department would continue our searching for records after Mr. Malloy responded. On September 26th, we submitted a request to our IT staff to conduct a search for records, and the department notes we would like to say that our SFIT staff are the only people in our SF Fire Department personnel with the technical access to enable them to conduct this type of search. It's not any personnel that could just go in. It has to be our IT staff that does that. On October 9th, we received the search results from our IT staff indicating that no responsive documents had been located. We were told there were no responsive documents. On October 11th, we issued my response to Mr. Malloy that the department didn't locate the responsive records. On November 4th, Mr. Malloy submitted his complaint to the task force here, and the complaint included a list of the fire personnel with whom he claimed he had corresponded to. The information had not been previously provided to us. The complaint also alleged that we had failed to respond to Mr. Malloy's request in a timely or complete manner in violation of the administration codes. On November 5th, in light of this information that Mr. Malloy provided, we did an additional search, and we came up with a responsive email message, and we provided him with that email message accordingly on November 6th. So we acknowledge that it's our initial failure to respond to Mr. Malloy's May 24th request until September 16th. We acknowledge that that violates the standards set forth in 6725 of the administration code regarding the immediacy of the response. However, we believe that we satisfy the other cited provisions of the administration code by disclosing all responsive materials in our possession as soon as those materials were located. Moreover, the department has identified the procedural issues that led to the initial delay in responding to Mr. Malloy, and we're taking steps to ensure that those issues are remedied so this doesn't happen again. We currently receive public records in two ways. The request seeking for property and building information and documents, which is the majority of the requests that the department gets. Our fire prevention personnel have primary responsibility for reviewing and responding to those requests, including those submitted via next request, which is how we got Mr. Malloy's request. For those records that do not relate to property, like Mr. Malloy's request, fire prevention personnel route those requests to me, so that way we are assigned to handle those requests. We discovered that the fact that multiple staff were accessing the next request and has in some cases led to confusion regarding whether or not the particular request on the system has been reviewed or addressed. And in the case of Mr. Malloy's request, the issue led to significant delays in responding. In September is when we got his response from the next request. We discovered this because our fire prevention did an audit of next request submissions to our department. And since then, the preceding requests in the required timeframes, we've fixed that, and we are processing to ensure that the timely processing of the requests going forward are met in the precise standards and the timeframes.
Okay, thank you. Is there anyone else here to speak on behalf of the respondent?
Good evening.
Hi, hang on one second. We're going to set the clock for you. Please go ahead.
Good evening. Jesus Abushan, Fire Department Human Resources. I just wanted to add to what John Tucker explained in regards to the use of next request. Unfortunately, because of the way it is opened by several people in the fire department, sometimes it's hard to tell what's been opened and read and what's not, and that's exactly what happened with Mr. Malloy's request, unfortunately. And being that the fire prevention personnel have primary responsibility over the next request materials, because a large number of public records requests are about property and permits, we didn't find out about Mr. Malloy's request until the audit was done over, I believe, between a 6 month period of requests, just to go over each and every one of them to make sure that non-fire prevention items were appropriately referred. But the minute we received that request, we reviewed it immediately. And then finally, in terms of the last batch of records that we provided, so in reviewing Mr. Malloy's rebuttal, we found some more information which we quoted in the response. And so I personally asked our IT director, being that he heads the IT division and he has a higher level of expertise in the department in that area, I decided just to be, just to continue in the diligent search, to ask him personally, can you do one final query based on these items in the rebuttal? And based on, I believe, his expertise, he was able to locate about 500 pages worth of records, which we immediately forwarded to Mr. Malloy. Jthank you.
I'm sorry, what was your name again?
Jesusa, Jesusa, Bushong, Bushong, Fire Department Human Resources. Thank you.
Thank you.
I
I have some ideas, but I'm gonna let you go first.
Okay, great. Okay, who should I ask this of? I think Ms. Bushong, I think maybe I want to ask you some questions here. You seem to have a little more knowledge about the next request system, and if not, then I'll invite Mr. Tucker to come and answer those questions. Who oversees the next request system? Is there anybody who does a regular review to make sure everything has been answered properly, or what the statuses of the requests or anything like that?
So as far as I'm aware, there's a team of at least 2 fire prevention civilian personnel that check next request regularly, several times throughout the day.
And in I don't know, how should I say this? Of those 2 personnel, do they only check for fire prevention document requests or information requests, or are they tasked with the whole system?
See, I don't know for sure. Because the majority of requests are for fire prevention, they definitely address those first. But in terms of who has the responsibility of referring non-fire prevention, I'm not really aware of a set procedure.
Do you have a public information officer?
We do. He's a uniformed personnel, but he is not involved in the Sunshine Ordinance compliance. So basically, John is our compliance officer for non-fire prevention requests.
Okay, great.
So I have a question, I guess, John, if you don't mind coming forward. You said that it sounds like once you responded to Mr. Malloy that initially you said we need some narrowing terms to be able to find this, and then there was some delay, and then finally you guys did a search for him and you said we have no responsive records. And then at some point there was one responsive email, and then there was another search done, and suddenly there were 500 documents. Can you explain what happened because I would think if you're asking for a narrowing request, it means the initial request produced so many documents in return that you had to narrow it down. But I don't understand how there was a delay because he hadn't provided narrowing terms, and then the query resulted in 0 documents. What happened there?
As from what my understanding is, when I received the request in September, I wanted to make sure that Mr. Malloy got the specific documents that he wanted right away. And so it was my thinking that if we can narrow down the request, then I can get him the documents that he specifically needed in case it did come up with a trove of documents. I wanted to be able to get him the documents that he specifically wanted, and that was my thinking. As for why the IT department came up with no responsive documents, I'm not sure why that is. I just know that as we got more information from like the names and stuff, we were able to produce more documents. So I'm not sure why.
Yeah, I mean, that's
our
confusing
tech-
because
I
usually
understand
if you
it.
have one term,
I was
it's
confused
going to
too.
return, a large circle of information, and then as you add terms, you get subsets.
Yeah.
Adding terms shouldn't suddenly unveil information that was not seen the first time
I
around.
understand, yeah.
So,
So, I mean, it's our IT personnel are the ones who are able to do these searches. And so when they did these searches, they informed me that there was no responding documents. And then as we got more information, the documents became available.
do you have other questions? Or I have some thoughts, but not necessarily
ahead.
questions. Something I'm thinking here, it seems based on, thank you for coming today to respond to this.
Of course.
It seems like you've been trying to respond, but there are some technical difficulties, or maybe, is there additional training needed in your department to be able to do this? Or do you need more access to the IT department to be able to respond to these kind of requests in a more timely manner? What would, it seems as though you are trying to respond, but that it's taking a long time and that you're not able to, or it was very difficult to respond in a complete manner. What would help you do that?
I mean, those are very good suggestions, and I will definitely bring it up to our IT person to see if there is any additional training, and talk to the IT department on why they didn't produce any documents the first time around or even the second time around, and so we can get to the bottom of that and figure that out. Those are very good suggestions. I will definitely bring that up to our IT director, who Jesus has said does have a very strong expertise in this and will be able to hopefully pass down his expertise to the other staff in the IT.
While you're there, Mr. Tucker, I have
Yes,
a
sir.
question. So according to Ms. Bouchon, you're responsible for all the non-property records requests?
Yes, sir. That's correct.
Okay. So do you monitor the next request system on a regular basis?
Again, it is the procedure that we have set up through Next Request is that the civilian personnel down in fire prevention, since more than 99% actually, of the requests that come in are for property records in which they do handle. And when they come across a request such as Mr. Malloy's, they would forward that to me, and that would be how I would respond to it and how I would go over the record collection process for that. So that's the procedure that we have set up. And
I think it was a little hard for us to hear that almost 3.5 months went by before a response to an immediate disclosure request.
I understand. And I know that our fire prevention, they get many, many, many requests per day. And as like Jesus has said, they check it multiple times a day. And unfortunately, I think that Mr. Malloy's request just was kept, it got pushed down. And as we did the audit of the next request to search through the records, that's when we found Mr. Malloy's request, and we proceeded to respond to it immediately.
Okay, and this is just a general question
Yes,
for
sir.
my own curiosity. Does the next request system have a special flag if it's an IDR?
It does not. I don't believe so.
Okay.
That's interesting, yeah.
I'm saying that because
I'm not an expert with Next Request, so I mean, there could be an option to where a requester could flag it if it's an IDR.
well, if they
But I
did,
don't-
the
I don't
question
believe there
is the person on the receiving end, are they able to see that plainly that it's, and that's something I'll review. I mean, if
In
you
my
didn't-
knowledge, I don't
that's
think
fine.
so. But
I'm just asking, I try to ask some of these kind of functional questions because this is somewhat of a new system for us to use.
Yes, sir.
And it's rolling out very slowly, every department, and we have a separate committee that reviews these kinds of systems. So It's just a,
Yeah, I know that only a few departments try and use the next request. Only a few departments are attached to
Right.
it now, and I know we want to be as compliant as possible in trying to
well,
be.
we want to make sure that everybody, it's working for everybody.
Absolutely.
So that you don't end up in this kind of situation.
Absolutely.
And
Yes, sir.
Mr. Malloy is not inconvenienced either, so.
Absolutely.
Yes, Ms.
Thank you, Mr.
Bashang, do you have
Yes, if you have.
another comment?
Sorry, go ahead.
Would you like to make?
On the subject of next request, John and I were actually talking about it, and we're not sure if it's possible to opt out of it. Because for us, we both check our emails or any SF.gov email address very, very diligently throughout the day. And so if we publish a dedicated email for non-fire prevention type public records requests on our website, we believe that that would probably be, just for our particular case, most efficient, and so that those types of requests would not be buried in like the 99% of fire prevention property type requests. But I'm not sure if
Well,
we're supposed to
that's an
use it.
internal, decision that the department should make, that if for the non-property issues, that you could put on the next request page or on your website, that it would notate for all non-property issues, please use this email
To
address.
create a second channel.
Create a
Yeah.
second.
Okay, so we are allowed to do that. I wasn't
we
sure
can't-
if.
We don't know.
We don't know. This
Oh,
is a
okay.
decision that I'm saying you need to go back to the department and kind of management and ask them if that would be appropriate, because, if you didn't use the next request system and you had a dedicated email address, this whole issue might have been averted.
Okay,
And
I just
that, I
thought-
would say, would be your argument for having it.
I just thought that it was a requirement to use next request
We-
by the
we-
Sunshine Ordinance. No, okay.
This was a decision that the city decided to use to implement, to try and alleviate the problems of, for a lot of the folks that came to us, losing or missing emails that came in through regular email channels. And that what Next Request does is provides not only a paper trail, but anybody that opens that, touches that file, it's recorded. It's explicit and exquisite. And so, that's why it was interesting to me that Mr. Tucker's original testimony, opening testimony, stated that it looked like, and maybe it was you that mentioned that when that particular Mr. Malloy's item came in, it looked like other people had seen it. But that usually when there's a response, somebody would notate that they responded so that they could show that there was compliance with the ordinance. So the fact that somebody opened it and looked at it and read it and said, oh, doesn't apply to me, and then the next person did it, 2 weeks later, that kind of thing, is not compliance. Just because it's notated on next request that somebody opened it, that's not a response under Sunshine. The response has to be direct. It has to be received by the requester as to what the situation is with regards to it. Now, just for your own edification, for immediate disclosure requests, all that's required is that a response that the IDR has been received is by the end of the following business day, which could be less than 24 hours, okay? Which may include the actual documents. But if it's maybe needs to be gotten from a different department or needs a search or what have you, you have the ability to extend that by 10 days. Okay?
Thank you.
And then if there are any other documents that continue to show up thereafter, as Mr. Malloy has mentioned earlier, it can be taken on incremental or rolling basis.
Okay, thank
That's
you.
the basic idea.
Thank you. I have one more question for Mr. Malloy. Thank you. And I apologize because I don't want to conflate the two cases. Can you tell us at this point, have you received from the fire department all of the documents that you want?
No.
No. Okay, what are you missing?
Since I knew those, and first of all, thanks to them, this is not a personal issue by
No,
any means,
we know that,
right?
yeah.
So Simon, for me, I know Simon at the end of his shift has to do recaps where he records everything that we did as a team, and all of these issues then go to senior officials throughout the fire department. Where are those written communications?
Okay, so there are different
So-
kinds of documents that you know exist and you haven't seen those yet.
Absolutely. So if I was
Okay.
sitting with the IT guy, I would say, put Simon's name in there because you know Simon communicated with him, and I know Brandon communicated with him, and then let's go follow that thread. And that's what's not happening, right? All of the records. And don't rely on me to tell you you have to have Simon's name in order to do that. If you're the IT guy, dude, put my name in like a Google search and hit it and just bring them up.
Let me ask you, just along this thread, do you have a list of all the people that would have those records?
No, because I wasn't with Simon when he did his notes or Brandon when he did his notes, because they do those at the end of the shift at the fire department. And so when issues come up or my records or.
But do you just know who they would be between?
No, I don't, because I don't know their chain of command.
So let me ask you, how would you describe a request for those records then?
All records, all written records concerning Stephen Malloy within the fire department.
Okay, got it. Okay.
Which is what I asked them for. And to your point, it's been this.
So you feel what you didn't get were communications about the records regarding you?
Absolutely.
Okay, got it, okay.
Okay, thank you.
Right.
It seems that this is something that should be taken up by the full task force.
Yeah, I want to, let me just ask the respondent, either of you, Mr. Tucker or Ms. Bouchon, sometimes what we try to do here, when things are already in process, I mean, there isn't an absolute resistance not to provide, okay? That's clear. We're not dealing with that. We're dealing with records, completeness of records. So are you aware of any other documents that might be provided to Mr. Malloy at this point? That he's, like, for instance, these communications between staff about records that he is requesting?
Personally, I'm not aware personally of any other additional records.
Okay.
But I am happy to go back and ask, and we can do a search or personally contact the people to see if there are any additional records or written records, as Mr. Malloy suggests that there may be.
Okay.
I'm happy to go back and.
Okay,
and do that.
I would appreciate that.
Absolutely.
I'm going to recommend that this be moved to the task force, and then we'll find out what happens at that time, whether you did find any, you didn't find any, you were ordered not to, redactions or, exemptions, or whatever the case may be. We'll find out.
And those kinds of updates are helpful because ultimately, Mr. Malloy is seeking the information, and it's our, if his request
Right.
falls under the Sunshine Ordinance, it's our job to try to help him get those.
Right. So, thank you very much. I appreciate it.
Thank you.
I don't have any other questions. I'm ready
No.
to make a motion.
Okay, would you like to make a motion?
So I move to find jurisdiction that we responded within the 45-day rule and that the records are public. And as a recommendation to the task force that we requested of the respondent to provide the any other or missing records that apply to Mr. Malloy. and that the respondent has acknowledged that request. And point two on that the respondent has, what the word, pleaded no contest to the
Delays, yeah.
timeliness of the response under 6725.
I'll second the motion. And is there any public comment on the motion? Seeing no public comment, let's call roll.
Member Wolf?
Aye.
Member Wolf, aye. Chair LaHood?
Aye.
Chair LaHood, aye. Member Hinsey, absent. Motion passes.
Thank you, parties.
Thank you all. Let's call the next agenda item.
So what I thought I would do would be to read the summary and then read the description of all the cases so that we would have it on record that we are in compliance with the 45-day rule. And it's on the record that, you have a question?
I'm not following what this is all about.
Most of these complaints are from certain individuals that we have received since like November 6th.
This is item number 9 on the agenda.
Yes, item number 9. And so Victor suggested that what we do is read the summaries into the record and have a motion to find jurisdiction. That way, we have met our 45-day rule with all these records. Do you have a question about that?
Yeah, it doesn't fulfill our job here.
Okay, well,
Our job here is not just to find jurisdiction and to be within the 45-day rule, but to also make sure that the record is complete and ready to bring to the task force. So
these cases will be heard in the future
by
committee,
by
either
complaint committee?
or compliance and amendments.
So it's not forcing them to go to the task force if we. Okay.
No, it's not that in any way at all.
Okay, so we're just a kind of, okay.
And then we,
This is just
Acknowledgement of receipt.
yeah,
got it.
jurisdiction, so that it's on the record that we have received these complaints. And we will then do a motion to find jurisdiction, take a
Okay.
vote, and public comment.
All right.
When I have a question on that, so since this committee is supposed to find jurisdiction before handing things up to the full task force, are we essentially finding jurisdiction for the committees, and then the committees find jurisdiction
Right,
for the task force?
right. It's actually for the benefit of the complainant,
Okay.
so that they know that their complaint has been read into the record.
Mm-hmm.
But it's not a full hearing
Okay.
on the complaint. It's not intended that way in any way at all.
The only problem I have with the 45, I don't think we can determine necessarily the 45-day rule because we don't know if the documents or the records for any of these cases are in fact public or not. We can assume that they are public, but then if we find later that they're not, then we've wasted everybody's time.
I'm not following you.
So the 45-day rule is specific. It is to determine if the records are public.
But the 45-day rule was to determine jurisdiction.
No. Jurisdiction can
But-
be done anytime. In fact, there is no requirement necessary for us to find within jurisdiction. When we have the hearing and we state that it's within jurisdiction is just to determine whether the complaint itself is applicable to the ordinance. But there's no, that's our own internal rule. The 45-day rule, the real purpose of the complaint procedure for the committee side is really the 45-day rule, but you have to first, the purpose is to find whether the records are public or not. If they aren't public, then it lets the requester know, both parties know in kind of speedy time that the records are either public or not, so that they can go about their business. If they find that the records are not public, if we find the records are not public, then they will have an opportunity to go elsewhere to be able to deal with them. But they have to know within the 45-day rule, 45 days to provide like a speedy trial kind of thing of that particular part.
Okay. I have spoken with a specific complainant about his many complaints. In fact, he filed 15 more today.
Mm-hmm.
And I mentioned the 45-day rule. He had no issue with having his complaints heard within a specific time period because he knew he had so many, and he also understood and accepted our two-complaint limit.
Did he sign a waiver of 45-day
No, he
rule?
didn't sign a waiver.
So that's the thing is,
He didn't sign a waiver. He sent me an email saying, yes, this is not a problem. I understand your procedures. I've read it.
well, but that's why we have the specific place on the complaint form for waiving the 45-day rule. It's very specific, and we've been doing that since the beginning. And the other thing is not having the actual files. I have no way to even review to review any of these. Now, we can determine jurisdiction, but it's not going to comply with necessarily with the 45-day rule. So that's really the issue that's happening here. And okay, so
All right,
I mean,
how
we
would-
can find that jurisdiction, but that's not going to satisfy the ordinance. The ordinance doesn't require us to determine jurisdiction. It only requires us to determine if the records are public. If the records are public, then it's kind of automatically within jurisdiction. The only other purpose to find jurisdiction is regarding open meetings. And, and other than document records requests. That would be the only other reason. Also, like in the first case with regards to SFMEA.
Right, right.
Does the agency actually apply to our body of law? And so that would be the other purpose of jurisdiction.
Well, the good news in this, I mean, if you scan the list, it does, the only one that jumps out at me is the University of California Regents. But otherwise, they are all city agencies.
Well, we don't know, I wouldn't be so quick about the university because there could be a situation where they may have contract. I mean, we just heard
Right.
a case
Right,
where.
I said that's the only one
Okay,
where I have
yeah.
a question.
Yeah. So that's the only thing. I would say that we can find jurisdiction because all the respondents that are listed here are city
Right.
agencies. So I would say there's jurisdiction because the parties are correct. But we have no idea what the detail is to be able to determine whether the items, we can't make, it's not about the 45 days, it's to determine whether the records are public or not. That's the case, because the other problem is that each one of those, that's going to be the hard part. You have to have the testimony, because if one of these is a investigatory case and they say it's still an open investigation, it's not public.
Right,
It's not.
right.
It's exempt from
Oh,
being
all
public.
right. Okay, so I hear what you're saying.
Okay.
How would you like me to handle this? Because this was a process that Victor had used in the past.
Well, I'm just wondering, like, these go back several months. I'm just wondering why they're coming to us now, and not back then for this, when they were, at that time.
Where do you see a date on them?
Well, look at the case number. It's 19,
Oh, I see.
2019. So, I'm just wondering if, as these were beginning to pile up, that's my only concern is that It's more a process issue I don't want to get into right now. How do we resolve this? Well, first of all, how many of these cases are beyond 45 days? And did anybody in this list waive the 45-day rule?
Just anonymous.
Just anonymous waived the 45-day rule? Okay, so if he waived the 45-day rule, then I would say, let's find jurisdiction on all of those.
And to be clear, assuming that anonymous is all the same anonymous, there are only 4 different petitioners represented in this list.
That's okay, that's neither here nor there, I don't think that matters.
I mean, since you said if he waived it, that,
Right,
yeah.
right.
He
Well, the
did,
question
right.
is if he waived those particular file numbers, that anonymous request complainant.
He did, and he sent me an email.
Okay, so,
That's what I was trying to say.
okay, so we'll assume that letter represents one person
Yes.
or one entity, by the, it goes by anonymous, for all the file numbers related to anonymous. Okay?
And then are you suggesting that we segregate out the other ones and have
Segregate out
those heard by the
all
next
the other
committee?
ones, and then we'll deal with those separately, just, it's a matter of process. Okay? Well, so, it'll be so I'll move to find jurisdiction, well, actually, wait a minute, let's just see. Okay, so here's the thing. Okay, so it's the reverse. If somebody waives the 45-day rule, then there's no scheduled time.
Oh, so
They
we don't have to
waive-
rush.
You don't have to rush.
Okay.
So let's take all the other items. So it's file number 19117,
19117.
191.
Excuse me, I got a email from Mr. Wu on Friday saying that he had received all his records.
Okay, so this
We
one.
don't have to worry about that
Okay.
one.
Okay, so is he pulling, did he pull, he pulled it, okay.
Yeah, he did, he
All
withdrew.
right, so skip that one. The next one is
19126.
Antrabo versus the Arts Commission.
Her complaints, she has 2 complaints, one's against the Arts Commission, one against Baumgartner. Different issues. She has agreed to appear in person for the complaint committee scheduled in February.
All right, but that second one is not listed here. It's only that one.
That's correct. I see her name once.
Yeah, 19126 is the only Antrabo complaint,
Okay.
okay? Then there's 19130, it's Stephen Malloy against Chesa Bodine and the DA,
Yeah,
okay? Hello. No,
Good evening, my name is Alex Passion, I'm here on behalf of the San Francisco District Attorney's Office.
okay, thank you. We're just going through a procedural issue right now, so appreciate your patience. So 19130,
19138, Mr. Malloy against University of California.
right?
And then he's also got 19140 against Department of Human Resources. And all the rest are anonymous.
Right, so, yeah, without being able to see Let me ask you something. Have these been reviewed by our legal counsel?
I had sent legal counsel about 10 requests for DCA memos. Not all these cases have been reviewed by the DCA.
So, point of information, someone in the audience.
Yeah, I'm 19145. I know I'm anonymous, but I'm here to state my case.
Oh, so you're not part of the, okay. All right, so let's pull, also list 19145. Thank you, anonymous.
So
Well,
you're a different anonymous?
No, I am the complainant, whatever you want.
Okay,
Petitioner.
Okay, we cannot identify.
Got it.
You
never
just
mind.
have to take it for whatever the face is. That,
Thank you.
so 19145, also put that on the list. Okay. Let me ask, are there anything else on this list that is applicable? Okay, great, thank you. So just 19145. Okay.
So let me
Cheryl,
just,
let me just ask, for the list that we have, can you tell me the dates that they were submitted? Tell us the dates that they were submitted.
not the exact dates, no. That's all on my spreadsheet on my computer.
Okay, so we have no way of determining the 45-day period. Hmm.
I have a thought. Because I know you apply the numbers when they come in order, could we look at some of the other numbers that were on today's agenda and reference around them? Would that be helpful?
Go ahead, let's
Okay.
try one and see if it
Okay, I'm
works out.
looking at, so the oldest one here is 19094, and we had on our agenda today, well, 19079 was number 8, and the
That was
date on that
September
one.
September 24th.
Okay,
Oh, but, yes, okay. So that
okay,
was
so
September
that, okay, and then,
Oh, no, but that wasn't, that's when it was heard by the complaint committee. Let's see when it was submitted. That one was submitted on July 27th.
and 19110 was submitted on November 4th.
I believe Mr. Malloy has a total of 4 complaints.
Okay,
UC, Fire Department, Department of Public Health, and DHR.
okay. So we know everything after the 19110 was filed November or December.
Okay. I think procedurally, what.
So the first two,
Either,
yeah.
if we assume, I think we have to assume that we're beyond the 45 days.
At least for the first
So,
several.
so already, we're going to have to plead no contest to violating the ordinance ourselves. That said, I think what we should do is just find jurisdiction because of who the respondents are, and get these, scheduled into committee as soon as possible, and just move forward.
Okay,
And then we'll have to deal with they'll have to be expedited. They'll have to be moved to the top. That's it. That's the way it's gonna have to work.
Well, that's what we were trying to do, is we have a lot of cases that we have already completed or have been withdrawn, and we're trying to get them, the oldest, to the top of the list for complaint hearings.
Yeah, I hear you. Okay, we're just gonna have to sit down and figure some of this out. Just for the sake of getting through tonight, I'm gonna suggest that that those, what are they, 5 or 6? How many are there? 1, 2,
Well, the
Three.
Conrad Wu one was dropped.
3,
We
4,
have 3.
5, 5, 5. I think it's 5. So we're talking about items number, not 19126,
Mm-hmm,
19130,
mm-hmm.
19138,
Mm-hmm.
19140, and 19145. Okay, let's find those to be within jurisdiction, and we'll notate for the record that it's assumed that that it's beyond the 45-day rule. The Sunshine Task Force will plead no contest to that violation, and these items will be prioritized for all available committees to hear. If it's at the very next committee, if all of them can be put into the next committee, then put them all into that committee. And otherwise, we're going to have to do special meetings for those committees. So, the idea is to speed this up for those parties.
So that's your motion?
That's my motion.
Motion to find jurisdiction and note for the record, it is assumed that it's beyond the 45-day rule violation and items will be priorities for the next committees.
It is assumed that it's beyond the 45-day rule, that the Sunshine Ordinance Task Force has plead no contest to violating the 45-day rule of, let's see what, hold on, let me get the provision for that. 6721E. And all these items are for public records under 6721, so I believe that's right. 67, right, 67. Hold on, 67, yeah, 21. I just want to double check, 6721, 6721. 6721, 6725. It's going to be the same difference anyway. Yeah, okay. Right. Go ahead, finish. And the rest of the motion?
I said it.
She said it,
Okay.
and I second the motion.
Okay.
Do we have any public comment on the motion?
Okay, before we finish, just for those people that are here that did show up for these complaints, the purpose of this committee is to find 3 things. One is to find that it's within the jurisdiction of the ordinance based upon who the parties are, who the documents are, what the documents are as we review them, and what's the third thing? I can't remember what the third thing is, but
To make sure the file is
the file's complete and that we have the complete file. Considering that these items, because of so many of them have come in, we're a bit backlogged, that the idea was try to move all of these at once by consent calendar to find jurisdiction. We can do that to find jurisdiction, but we can't comply with the 45-day rule. So I want to do the first one for the 45-day rule and get those
26?
prioritized, because the rest of them, the 45-day rule has been waived. Okay. All right.
There was no public comment.
Ready for a vote?
Please call roll.
Member Wolf?
Aye?
Member Wolf, aye. Chair LaHood?
Aye.
Motion passes.
Did we need to say that?
And then, now I'm going to move items 19094. Cheryl, just for your sake, it's all the other ones that are not in the previous motion. I'm just going to say it for the record. I move to find jurisdiction and jurisdiction only for file numbers 19094, 19097, 19119, 19120, 19121, 19122, 19125, 19128, 19131, 19132, 19133, 19134, 19135, 19136, 19137, 19139, 19141, 19143, 19144, and 19146.
And I second. Do we have any public comment on the motion? Seeing no public comment, let's call roll.
Member Wolf?
Aye.
Chair LaHood?
Aye.
Motion passes.
Okay, thank you for parties that attended. We're sorry, but we are not prepared to hear these cases today. We don't have the documentation, and the file is not complete yet because we don't have legal counsel memos ready for them, and the collation of the files is not yet complete. So those cases from the first motion will be immediately agendized for the next possible complaint committee that hears complaints. We have 3 committees that hear complaints. The complaint committee is the priority, and then the education outreach and training is and the compliance and amendments committee, which is this one, are secondary for any overflow from the complaint committee. And those will be scheduled accordingly as soon as possible. And if I'll, as the chair of the entire task force, if I find that the next available committee is, well, let's say more than 2 or 3 weeks, then I'll do what I can to get quorum to schedule one of the committees to meet sooner.
Would it be possible to put on the record?
You can please come up to the microphone. I'll allow you to
Thank you.
speak to this.
Hi, my name is Alex Passion from the San Francisco DA's office. Would it be possible to either put on the record or put on the minutes that the district attorney's office was present, ready to argue, ready to handle this matter, and just to be able to put some of those things on the record in the abundance of caution that on the next scheduled date, perhaps we may not be able to be here? Is that possible?
Right, you've stated it for the record, so it's on the record.
Thank you.
And we will confirm that.
Thank you.
What will happen is when it's ready to be scheduled, our administrator, Cheryl Leger, she will be contacting you directly, either by email or by phone or by both,
Okay.
some form of communication to determine what availability you have for those particular dates.
Great,
And we
thank you.
strongly encourage you to participate or to send a representative.
Yes, and that's why we're here
Great.
today. Thank you. Thank you, Cheryl, too.
Thank you.
You all have a good day.
You too. And sure,
Please.
anonymous, if you want to come, and anybody else who's party to this.
Thank you all.
Thank you.
Okay.
Yeah, so I'm not really familiar with all this legal jargon. So what's going on with 19145?
So the ordinance requires the task force to determine whether the records being requested are public within 45 days of receipt of the complaint. Your complaint was submitted probably sometime over the summer.
No, this is one of the more recent ones,
one
and in
more
fact,
recent.
might,
Oh, I'm sorry.
Yeah.
November, December,
Yeah.
okay. So we're required to find whether the records are public or not within 45 days. We have to be able to see what records are provided, or what the testimony from yourself and the other party is with regards to what these records are exactly. And we have a particular hearing procedure to do that, I don't know if you were here earlier to hear any of the other ones. So because of this unusual situation, we made a motion, the first motion, which included yours, to immediately find jurisdiction and to admit that we exceeded the 45-day rule, and to prioritize your case to be heard at the very next committee meeting so that we can finish the process.
And is this going to be a committee meeting regarding jurisdiction, or is this the actual hearing?
No, it's actually part two of the complaint process at the committee level. If we split it up into parts, part one is first to find jurisdiction and if the records are public. Part two is to make sure that the file is complete with all the information necessary so that when we send it to the full task force, they have a complete file. They are fully informed with all the proper information. Those meetings have to move very quickly, or it's kind of expedited. And so if people start bringing in records or files in the middle of that hearing, it makes those hearings go very long. And we usually allot 45 minutes to an hour for each one of those hearings. So we try to reduce that. We try to help streamline those hearings by making sure at this level we have all the possible documents. So both parties are here. You can determine, if you say, I didn't get all the documents, they say, well, maybe we didn't understand what you were asking, and we can kind of figure out all those gory details here at this level, and so that we're not wasting everybody's time at the full the main hearing.
right, because sometimes you get to the main hearing and realize there are documents missing, and that we should wait and have a second hearing, and it becomes frustrating for the participants to have to perhaps wait another month for the case to be adjudicated.
Okay, great. So does that mean 19145 passed step one?
Yes.
And now moving on to past
Yes.
step two?
Yes, step
Okay.
two would be to get it before another committee like ours as soon as possible.
Okay, great. Thank you.
You're welcome.
Thank you.
Okay.
Next item, please.
Yeah.
Item number 10, announcements, comments, questions, and future agenda items by members of the Complaint Committee, Compliance and Amendments Committee.
I'd actually like to go back to the discussion about the A, B headings earlier, where we were talking about determination of jurisdiction and then hearing on the complaint.
Right.
I remember several months back, and I think this was before I was chair, that there had been a discussion of needing to break out jurisdiction versus the other things. And maybe since Cheryl went back to a way it was previously done, perhaps we need for a B determining, completeness of file or determining public records.
I think it's just, it's part of the purpose of it being in the complaint
Then why do
process.
we call out determination of
I
jurisdiction
don't know.
anyway?
I don't know. And frankly, to be honest with you, because I don't participate at the complaint level that much, I'm not reviewing, and I'm allowing the chairs to kind of run the show on those. I'm just saying that I think it's confusing for the parties, that they'll start saying, well, are we hearing this today, the full thing today? And then we have to take up extra time to tell them that no.
Well,
Did-
when we send out that notice of that there's a jurisdiction hearing, we bold in capital, your attendance is not required. If you have any questions, let me know.
Oh, okay.
Jurisdiction notice sent out.
And do the agendas for the complaint committee, are they set up the exact same way with the A and the B?
Yeah.
Okay.
Hold on a second. So I'm not following you. The parties are not, you're saying the parties are not required to show? I'm not familiar with that. I believe that we went through painstaking rules, adjustments to make sure that that all parties participate at both times.
All parties participate in the hearing that was noticed today,
Yes.
where we heard the parties. 2 of them withdrew because they had received their records. In addition, Victor has told me that what we should do in a case where we have this many complaints that have come in as a slew,
Right.
to find jurisdiction and get a motion on the record that at least the case numbers were heard. There is no requirement for the parties to show up. It's just to get it on the record.
Yeah,
I see.
no,
So not for-
I don't
okay.
want to discuss this
Okay.
right now. That's not what I'm asking about. I hear what you're saying. I'm not in agreement with that. Let's just, with regards to your point, I think the A should just be determination of jurisdiction, compliance with the 45-day rule, to determine records are public, and completion of the file.
Right, but it's our compliance with the 45-day rule, not their compliance with the 45-day rule.
So is it
Right.
acceptable to just say determination of jurisdiction?
I don't think it's even necessary to say that. I think it's,
We could just list the items?
I don't think you even need to list, I don't think there needs to be anything there.
Right, that's what I'm saying. So you're just saying, list the case number.
Case
With the
number.
summary and get rid of the lines A and B entirely.
Entirely, because we already know what the motion is
Yeah,
required to be.
Right.
Okay? I mean, I think if anything, the, all of these items could be listed under the heading of, something like, jurisdiction and completion of, complete record, or something, I don't know how to word it, but just so it's known what folks are here for, or maybe there'd be like a note, like just after public comment,
That we
or-
read a note, say the purpose of this
purpose of
committee
this
is to determine jurisdiction, and if jurisdiction is determined, make sure that the records are public and that the file is complete before
Right.
we send it to the full task force.
Right, and because the assumption is that it's happening within 45 days.
That part is happening within 45
Yeah.
days, not the full task force
Right.
part. Right.
Correct.
Right. The assumption is that it's happening within 45
Right,
days.
the 45-day part is on
Right.
us.
Our responsibility, not theirs.
That's right.
Yeah.
Because the reason why I'm saying is delineate it is because each committee has its own charge, except the complaint committee.
Right.
Okay, but even the complaint committee may have other items not pertaining to finding jurisdiction. It could be like review of the complaint procedure. you know,
Right.
So
Right,
that
right.
if you delineate the complaint part from the rest of the work of the committee, I think that makes it more clear, because the purpose of the other two committees is not to hear complaints primarily. They have their own charges for other kinds of work. And especially with us, with compliance and amendments, we might have case numbers that are applicable to referrals from the task force to review for compliance.
Right.
Okay?
Right.
Or it may be to review amendments to the ordinance.
Right.
So those, I think we should create some delineation in the agenda for what is the jurisdictional complaint procedure part
Section.
versus the charge, other topics that are part of the charge of the committee.
One other thing that I remembered, and I thought about it coming in and then I forgot about it, the statement that we're supposed to read at the beginning about calling for decorum.
Right.
Can we throw that on every agenda? Just, yeah.
Didn't happen
Yeah,
on
yeah,
this one.
yeah.
Yeah, it's fine.
I wasn't sure if we had asked for it at the committees, but yeah.
Okay, let me just say one thing.
Yeah.
This is how I was trained, was to create agendas for compliance, for complaint, EOT, that have the same language, because they've been hearing different complaints. And I was trained to make sure to include those two sentences.
Okay.
That's why it's there.
Okay.
And if you want to change it, that's your prerogative. I'm just saying, I wasn't doing something wrong. This
No,
is
no,
how I
no.
was-
I'm not
Yeah,
saying
yeah.
it was wrong.
Yeah.
Not saying it was wrong. Just saying that it's confusing it's confusing to me because and it would be confusing to members of the public. You know, it's not the first time that somebody would have said, so are we having, like this fellow here, are we having the hearing today?
Right.
You know, or are we having the full task force hearing because there were almost 3 years where the committees were actually running through the entire complaint process and just making a recommendation for the final determination to the task force, and the task force was just rubber stamping that.
Because there was so much going on?
Because there's just a big backlog, and that was the way they felt to expedite it. That is to me, a complete violation of public's trust, because there are 11 seats here. They should have the benefit of 11 brains and minds to go through the actual process,
Okay,
and not
I just
3.
have one thing to say about that.
Yeah.
I also made it clear at the last task force hearing how many complaints had come in and the days that they were received.
Yeah.
That was noted. I don't have that with me right now, but you guys should have that on your computers.
Oh,
In your
we could have looked it
agenda.
up. Right.
Yeah, this is something I don't want to discuss this right now. I will want to have a separate discussion about this.
Well, and you were doing what Victor recommended, so we,
If you don't
It's been
mind,
done before.
yeah.
I would just prefer not to discuss this
Okay.
here. Okay. We're not done with the meeting yet. I don't have any
That
other.
was my only
Okay.
question.
Okay, I don't have anything else.
Let's call the final item, please.
Item number 11, adjournment.
I move to adjourn.
Is-
I second. Meeting is adjourned. Thank you.